Okay.
Good morning, everyone. Happy Friday. I hope everybody's having a good start to their Friday morning. We're excited to launch our first commercial training of 2024. So this is going to be session 1 of 2. As Michelle indicated earlier, there's a lot of stuff that we're going to be covering today. So please take a notebook, pad, take some notes, jot down your questions or put them in a chat, and Michelle will attack those questions after the training, okay? So please refrain from interrupting her so we can get through all the data, and then afterwards we'll answer any questions, okay? So without further ado, Michelle, the floor is yours.
Thank you very much and welcome to AIR CRE contracts training on the standard offer, agreement, and escrow instructions for the purchase of real estate, non-residential. So I was wondering last night, what does AIR stand for? So because I've never really heard anybody say anything but AIR, so I looked it up because I was extremely curious. It stands for, or used to stand for, American Industrial Real Estate Association, which was formed in 1960, but now it is just called AIR. CRE stands for commercial real estate. So that's just a little trivia for you because I was very curious, so I wanted to look it up. So today's going to be a fun day. We're going to go through this agreement. We're going to get down to all the way down to the contingency periods, and that will be the first half of the training. As Ruben said, please refrain from asking questions during the session. We will go back at the end and answer all of your questions. And if you have deal-specific questions, we'll also help you with that probably offline, okay? So let's get started. And this is going to be a really fun training session. And here we go. So the dated up here is for reference purposes only. So if I was typing this up today, I'm going to put in January 19th. So this is only for reference purposes like you've seen on the car contracts. The buyer, you're going to insert the buyer here. Now, if you have an LLC or a corporation, make sure you're putting the domicile in or where that corporation was formed. For instance, XYZ LLC, comma, a California limited liability company. You want to put that in. Now, how do you find that out? You could ask your client, the buyer, for a copy of their Secretary of State, the information document. You could go on to the Secretary of State website and look yourself for California. Some of these will be Delaware corporations or limited liability companies, but make sure you're inserting for an entity or a trust the full name and that you have the proper authorized signer. That's the reason you may want to check on Secretary of State, because you don't want to do all the work and then not have the right name. The reason why is because there could be other LLCs across the country named XYZ LLC. So we want to put in the domicile or where that LLC or corporation was formed. So this is an agreement to close escrow 30 days, or we can insert different days here. Now this is going to be a little different. Remember that the clock starts on the days of escrow after the waiver or satisfaction of the buyer's contingencies. That will be established as the expected closing date. So we're going to get down to all of the contingencies today, so you'll see what those timelines are. But bear in mind, on this contract, it's after the waiver or satisfaction of buyer's contingencies. So it's kind of a floating date, if you will, but it will be after all of those are removed or satisfied, okay? And we'll explain it more in paragraph 9. The escrow holder, you're going to insert here. And I always recommend that you put an escrow officer. I can't read that, I'm sorry.
Are you recording it?
I'm recording.
Okay.
Okay. So you want to put the escrow holder. I always recommend you also put the escrow officer in, because, you know, there may be, maybe the seller has somebody in there that they would prefer to use. If you don't put your officer, you may not get your choice, but maybe the seller will counter you anyway. The address, the phone number, normally I don't put a fax because we're not usually using fax, but if you have it and you want to put it, go ahead. So you see agreements written with and or nominee or assignee. In this agreement, we do not need to put that in here, and we do not recommend that you do. And the reason why is it's already stipulated in this paragraph that the buyer has the right to assign the buyer's rights hereunder, but the assignment does not relieve the original buyer of the obligations under this agreement. So if you have a buyer that is assigning, you know, if they're signing to creating an LLC to put this property in, no problem, it's their own. But if they're assigning to somebody else, make sure that they do understand that they're still obligated, even after the assignment under this agreement, unless the seller releases the original buyer. Okay, so make sure that you all understand that. If you're representing a buyer, that your buyer understands that, okay, for assignment purposes. The date of the agreement, section 1.2, is when agreement is reached. So what is going to establish that is the end of the counter offers, or if it was just the agreement, it'd be the last date signed, or the last date of the counter offer, which is pretty standard. We always do that anyway on car contracts if we're making a comparison. So that would be the date of the agreement. Remember, at the top, that's only for reference purposes, okay? Let me scroll a little bit. Okay, so 2.1, the property that is subject of this offer consists, we're gonna put a brief description. So one thing that we do not recommend is please don't insert square footage, even if you put approximate, because even the assessor's data, maybe it's not the same. Maybe there's been some upgrades to the property and it hasn't been updated on the assessors. We do not want to make the square footage an issue. So you might put industrial building, or even though you're going to put the address down below, you could insert the address here, but don't tie it to square footage. When you're representing a buyer, make sure that you remind them that they can, hi, welcome. Here's the handouts and a piece of paper if you guys have questions. We just got started, so you're right on time.
Oh, thank you.
So the real property, we don't recommend that you insert square footage. You can manage your buyer's expectation by advising them to have it measured if they desire, because sometimes there's changes that even agents wouldn't be aware of, or the seller hasn't measured it themselves. So let's not make the square footage an issue, you know, but do advise your clients that they can measure it. So you're going to put the county here, the whole address here, and legally describe. That's the legal description that's found on a title report and the APN number. So if you don't have the title report up front, then you can go ahead and look it up on Realist, on you know, the MLS. Now, you can insert that there, but you're going to look at 2.2. It says if the legal description of this property is not complete or inaccurate, the agreement's still valid. So it's not going to invalidate the contract. And here is where, if you want to try to take choice on your title company, you will insert the title here. I always advise that you put the title rep as well in case the seller knows that title company and has a different rep. So you would insert the title company here and the rep's name. And you'll probably, you know, the seller, this is a part that the listing agent is going to pay attention to, and they may counter that. So just be aware, okay? So 2.3 is what the property includes, like that are attached to the property: permanent improvements such as HVAC, fire sprinkler systems, power panels, things of that nature. Normally, as a buyer's agent, you may not know, because you can add other inclusions. If there's something you saw that you would like included, add it here. If not, you know, leave that blank. 2.4, we're on the fire sprinkler monitor. So you have 4 choices here. As a buyer's agent, you may not know who owns that fire sprinkler unless you've specifically asked. So you want to look at your boxes to check. You could check is owned by the seller and included in the purchase price, or it's leased by the seller and the buyer will need to negotiate a new lease. Listing agents and buyer's agent, if there is a lease on a fire sprinkler, make sure that you have the copy ready to supply to the buyer so that they can read it and negotiate a new lease with the monitoring company. One that we see commonly checked is the ownership. We're on 2.4 and in the contract. The ownership will be determined during escrow. That's perfectly fine to check. If you don't know, or if you know for a fact there's no fire sprinkler monitor, you could check that. But generally I see in most, I'm seeing ownership will be determined during escrow. Okay. I'm sorry, I'm having a problem with my scrolling here. Okay. So 2.5 is an exclusion. So it's telling you that this purchase does not, price does not include the seller's personal property, furniture or furnishings. And if there was something else that was excluded, it would be typed in here. Normally as a buyer's agent, you're not going to be excluding things. Maybe the seller's agent will provide a counter and exclude something. So I point these out because it's something that both seller and seller's agent and buyer's agent need to be aware of specific paragraphs. All of them are important, but there's some they may need to counter on. So right here on 3.1, you're going to insert the purchase price of the asset that you're making an offer on. Purchase price you're offering. Why am I having a problem? Okay, there we go. So the purchase price is inserted here. So you see it says strike if not applicable. So from down below, if it's A will be applicable because cash down payment, including the deposit, or if it's an all cash transaction, you're going to insert. So if it's $1 million, you're going to insert $1 million here. If you are obtaining a loan on this property, it would be $1 million here. Let's say I'm going to put 500 down and I'm going to obtain a loan for 500,000. So that's how these work. Now, if you are not assuming any notes or anything, first or second notes on the property, you may strike these remaining paragraphs. If you are doing that in this offer, you're going to probably have already needed to talk to the listing agent to know what these notes are, and you would fill all this in. And they have room here for a first and second note. Or if the buyer is giving the seller a purchase money deed of trust, you would insert that amount here, and then it's going to calculate it down. So usually it's cash to new loan. So you would probably be striking out these, but in some cases you will be making an assumption. And that's something you would want to talk to, knowledgeable parties on, and that can advise you on assuming and things like that. Okay. So the total purchase price is going to calculate down here. So 3.2 is important if the buyer is taking the property subject to or assuming an existing deed of trust, because the fees can go up to a maximum, and it's already embedded in the contract of 1.5% of the unpaid principal balance of the applicable existing note. So make sure that as a buyer's agent, you are paying attention to 3.2 if you are making assumptions, and you can negotiate this, but make sure that you understand that there's a built-in percentile in 3.2 if that is the case. Okay. So I will always stop and point out paragraphs I think you should really pay attention to and why. So the deposits 4.1, we don't have checks delivered to the brokerage. We want it to go directly to escrow. So 4.1, the first checkbox would not be applicable because here we would like you to have them send it to the escrow. So you're going to check this box, and you see the default on this contract is 2 business days after the execution of this agreement, full execution, that the buyer is going to deliver to the escrow company a check in the sum of right here. So you're going to insert that. We will get down to liquidated damages in training number 2, But right now, I want to tell you, there's a 3% cap on residential, as we all know, but there is not a cap on commercial. So I will show you how to protect your client in step 2 and class 2 on the liquidated damages. So you put the sum here, and we'll go over liquidated damages in class 2, and I'll show you where you insert that amount, okay? Because I have a feeling people are thinking, well, what about liquidated damages right now? So I wanted to say that. Additional deposits. Usually we're not going to see A utilized too much, that somebody's going to put an additional deposit within 5 days of the date of the agreement. Generally, you're going to see it more pertaining to number B, 5 days after the contingencies discussed in paragraph 9.1 A through M are approved or waived by the buyer. Then the buyer would deposit an additional sum or not. So it doesn't mean that they have to, but I generally don't see A used. It's more with B, where they'll offer an additional deposit once they waive the contingencies or approve or disapprove them. So if you have an escrow company that you're using and maybe they don't use AIR contracts all the time, 4.3 is going to be an important paragraph to point out to them. So I always put E by them. So this is ones that you would be highlighting for your escrow officer to make sure they're following it. So escrow holder will deposit the funds that the buyer deposited into a bank in an interest-bearing account, state or federally chartered bank, into an interest-bearing account, okay? So the only way that escrow can deposit that into an interest-bearing account on behalf of the buyer is that you provide the buyer's federal tax identification. So I recommend that you put that up top so there's no delay in them establishing that account for your buyer. So please, if you're working with an escrow company, you know, they should know this, but if they don't, I always highlight the paragraphs in an email and boom, 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 because there's a couple of them they're going to need to be watching for. Okay, so 4.4 is another E for escrow that you need to be aware of, but also your escrow company needs to be aware of. Within 5 days after escrow receives the funds deposited, escrow holder is going to release $100 out of those funds to the seller as independent consideration for the seller's execution of this agreement and the granting of the contingency period. So this $100 is non-refundable. If this doesn't close, it's not refundable to the buyer, but it shall apply to the purchase price upon closing. Why is this here? Because of a lawsuit. So there was a lawsuit. I don't know all the specifics, but I do know that a buyer and seller went to court and the seller said there was no consideration for me to grant the, you know, the contingencies or whatever. So AIR, to head that off, inserted 4.4. Some agents have talked about lining this out and not doing it. We don't recommend that. AIR has been, you know, doing these contracts since 1960. So for me, excuse me, I'm going to highlight that to escrow and make sure that they understand to release that $100. And you can explain that to your buyer as well. So upon waiver of all of the buyer's contingencies, then the deposit becomes non-refundable, but applicable to the purchase price. Okay, so one thing I want to mention here is this contract is passive removal. Silence in this contract equals acceptance. So as an agent, you're going to need to be very updated and following all the contingencies. We will see them in 9.1 that we'll go over. You need to make a chart, follow those contingency lines, because if you don't disapprove them, and AIR does give you a form, disapprove them, and I included that in your package, then it means it's deemed that you've accepted them. So this is a passive removal. If you don't say nothing, then you have accepted all of it. And escrow is more involved in this contract because not only do you need to let the other broker know, you need to also, the selling broker, you need to let escrow know right away of any disapproval. So escrow's more involved in this contract. So if you disapprove any of the contingencies, you will notify all the agents and also escrow. Okay, silence equals acceptance. One thing we need to remember on this contract, because it can be a little bit confusing because it's a passive removal, not active as it is in a car contract. Okay, so financing contingency. 5.1 would be if you are obtaining a loan on the property. This would apply. So like in the first scenario I gave you, it's $1 million, 500 down, 500 loans. So it would be 50% of the purchase price. So you insert the amount here that the buyer is obtaining a loan for, the percent of the purchase price, and that's considered a new loan. Now, if this agreement provides for the seller to carry back any junior financing, then the seller would have the right to approve the terms of the new loan for junior financing, and the seller would have 7 days following receipt of the commitment to either approve or disapprove. So it says right here, strike if not applicable. So if this is an all-cash deal, none of this would be applicable. But if you are obtaining a loan, 5.1 would certainly be applicable. 5.2 is very important because it's telling you that if the buyer fails to notify its broker and escrow and seller in writing, and you're going to insert the days here, because this is about the loan, within blank days following the date of agreement that the new loan has not been obtained, it shall be, here we go, conclusively presumed that the buyer has obtained that loan or has waived it. So again, silence equals acceptance. So make sure on 5.2, if you have a client getting a loan, that you're watching that timeline as well. Add that into your contingency checkoff, okay? So if the buyer notifies its broker, escrow, and seller in writing within the time specified in 5.2, the days you put in that you think it'll take to get the loan commitment, that the buyer has not obtained the new loan, this agreement is terminated and the buyer is entitled to the prompt return of deposit plus any interest they earned on that account. Okay? Less, if there was any fees, cancellation fees or costs. The 100 is non-refundable. Okay? Seller financing. I'm not going to go too much into financing. Suffice to say, if you are doing financing, please fill this out. And if it's not applicable, you may strike it in this agreement. There's a way to do strike lines through this. Okay. So I'm going to skip past the seller financing. If you are helping a client with seller financing, make sure they're talking to a professional in that field that will understand the financing aspect and get help on that. Have them get some help on that. So real estate brokers. So at the top of this offer, we're going to have agency disclosure as we always do. And the listing agent on the listing agreement is going to have their AIR agency disclosure as well. But as we do in car, you need to also fill this out properly. And you need to fill out the firm, our license number, the selling agent, their license number. And you're going to check 2 times if they represent the seller only or both parties and their dual agent. And the same down here for the buyer's broker's form. Make sure that the license numbers are all filled out right. Listing agent, if you notice they're not right, please counter those and correct them. Okay. And remember, as we all probably know, that if there's 2 agents from Coldwell Banker George Realty representing, one representing the buyer and one representing the seller, we are a dual agent. We have a fiduciary. Both agents have a fiduciary to both parties because you're under the same brokerage, okay? So this is important to fill out because it's the acknowledgement that other than the brokers listed above, there are no other brokers or agents representing the parties or due any fees or commissions under this agreement. So this last sentence here is very important. Buyer shall use the services of the buyer's broker exclusively in connection with any and all negotiations and offers with respect to this property for a period of 1 year from the date inserted at the top for reference purposes only. Now, why am I reading that? This would be a question for a lawyer, but let's say somebody bought a property and they weren't intending to hold it for long term. Maybe they were going to do a fix and flip or something like that, and they went with a different buyer. I don't know, maybe the buyer's agent, the original one, would have a claim if it was inside of a year. But that is a lawyer question, but I want to point this out because the AIR contract does have some protective clauses for agents built into them. So just be very aware of this clause here. Okay. And 7.2 is just saying that the buyer and seller represent that they've had no other dealings with any person or firm in connection with the purchase and negotiation of this agreement. Okay. So escrow and closing, acceptance by seller of this agreement, including the counteroffers incorporated, constitute the agreement and escrow instructions between the buyer and seller. On the AIR, they do not want escrow adding any other terms really, other than, purchase price and that kind of thing, and their boilerplate, but they don't want any other terms added. This will be connected, should be connected to escrow instructions because this is your escrow instructions, okay? It's pretty much, I believe, the same on residential too. Those are our escrow instructions. So 8.2 is another E for escrow. As soon as practical, after the receipt of this agreement and any of the counteroffers, escrow is going to ascertain the date of the agreement, meaning when was the last person signing on the agreement or the counteroffers. So, and then escrow is going to advise the parties and the brokers in writing that date. So that's an 8.2 is another E for escrow that I would highlight to them. So let's see. In the event there's a conflict between the law of the state where the property is located and the law of the state where the escrow holder is located, this shouldn't happen to us much here, but anyway, the law of the state where the property is located will prevail. We're usually using escrow people here, okay? So subject to the satisfaction of the contingencies, escrow holder will close the escrow by recording a grant deed. 8.5, put a big star by it. This is something we all need to be paying attention to. This is a built-in. This is probably okay for Southern California, but you may want to amend it. Northern California has different structure. Buyer and seller each pay 1/2 of the escrow holder's charges, and seller pays for the usual recording fees and any required documentary transfer taxes. Seller will pay for a standard coverage of title policy insurance. So if these fees aren't agreeable, excuse me, to your client or the other client, maybe the listing agent will counter it. Maybe you'll amend this paragraph. So I just wanted you to be aware of 8.5 because they've already built the escrow fees in, okay? And you can amend it if you need to. 8.6 is another E for escrow. Escrow holder shall verify that the buyer's contingency have been satisfied or waived prior to closing. That doesn't alleviate the agents from not checking as well, but this is one that you need to let escrow. They need to verify that all of the buyer's contingencies have been satisfied or waived. Okay, and we'll go over paragraph 9. So if this this deal is terminated for non-satisfaction and non-waiver of a buyer's contingency, like I said, AIR has a very nice form if they don't agree with something they found out. Then the agreement can be terminated and the parties would not have liability under this agreement to each other, except for if there was a breach of any of the warranties or covenants in this agreement. So in the event of a buyer termination, the buyer shall be refunded all their funds deposited by the buyer and of course their interest, less only the $100 provided. And if there was any title or escrow fee cancellation fees, okay? So if it was terminated because of a seller's breach, then the seller would need to pay title and escrow fees, cancellation costs, okay? So 8.8, the closing shall occur on the expected closing date as soon as escrow is in condition for closing, okay? And that means that they've already verified that all of the contingencies have been waived or accepted. Okay, hang on. I think I'm going to get right into the contingencies. So we're going to go into the contingencies. This is where I started one on Excel myself. I just haven't finished it. I would make a chart of this. If you're heavy into commercial and you're going to be doing a lot of commercial deals, even the up top ones where you got to monitor days, I would make an Excel spreadsheet or whatever program you're comfortable on and line these out, because there's a lot. And like I said, it's passive. So we want to make sure, and you can provide that to escrow too, if you make that chart, and to your client. So contingency, if before 9.1, if before the expiration of the applicable time, buyer fails to provide escrow holder written notice of buyer's disapproval of any of the buyer's contingency or any other matter that is subject to the buyer's approval in this agreement, then the buyer shall be conclusively deemed to have satisfied such contingencies and or approve the matter. So again, they're warning you, this is passive. If you don't say something's wrong and you don't waive it, if you don't point it out on the form in writing, then it's deemed that you've accepted it, okay? So there's certain items that have to happen that will start the clock ticking on some contingencies. So I'm going to try to point those out. So when you take your listing, you can have the seller fill out the property information sheet, and we'll go over that in the second training. Seller's mandatory disclosure statement. That's fairly simple. You attach an NHD to it, and there's a few questions they answer on that form, but get those done right away because you can get an NHD report within an hour. It's simple. So have your NHD ready, have these forms with you, and get it done with the listing. If not, get it done in the same week. I wouldn't recommend going over a week because some of these we need to kick off the days on, you'll see down here on some of these. So let's see, physical inspection. The buyer has 10 days, or you can amend the days if you feel you need longer. Following the receipt of the property information sheet. That's why that's so important. It's going to kick off the clock on this one and a few others. So if you need longer than 10 days, you can go ahead and amend it to satisfy itself with the physical aspects. And here we go, size of the property. One thing I want to stop and say is sometimes on these warehouses, you'll be staring at, oh, that's a beautiful lot. It's so big. And there could be a row of warehouses. Make sure you understand, because I've seen this happen, what parking lots belong to the building, because sometimes the buyer may be staring going, nice, but that belongs to a neighboring property. So make sure when you are representing a buyer that you are not only advising them to please check the size of the asset, the building, but also parking lot, because I did just recently see a confusion where they thought a neighboring property parking lot, because it was all like one was theirs and it wasn't. So you literally have to make sure that you understand that, okay? And the listing agent should be able to provide you that information. Hazardous substance and condition report. The buyer has 30 days following the receipt of the property information sheet or the date of agreement, whichever is later, to satisfy itself with this environmental. Soil inspection, the buyer has 30 days following receipt of the property information sheet to satisfy themselves with this. And this, let me see, this is pertaining to the compaction, I believe. Hang on, I have my notes when I was studying. It's a compaction of the soil. Let me tell you what it is, because I wrote it down. Oh, this is for the compaction and the type of soil that exists on the property. The soil inspection is compaction and the type of soil that exists. It might be important for building, you know, so. Government approvals, buyer has 30 days following the date of the agreement to satisfy itself with regards to permits from the government agencies or departments and things of that nature. You know, I would imagine that the buyer may want to go to the city and check on things to make sure they can operate their business or what they think they're going to operate there in that building. Conditions of title. Now we're going to spend a little time on this. Conditions of title. So escrow holder shall cause a current commitment for title insurance, and it says title commitment. It does not say a preliminary title report. It means exactly what it says. It is a title commitment concerning the property. So what is a title commitment? It's a higher level than a prelim. And what it is it's a okay, it's a more in-depth dive into the property. So when you are representing either the seller or the buyer, make sure that you are provided a title commitment, unless you're amending this to a prelim, but I would say get the title commitment. It is going to take 5 to 10 days to obtain that. Listing agents, when you get an offer and you have the buyer's name, because the title company will request that, you order that title commitment. It is not going to cost your party anymore. It will cost you days. So get that done at the top. As soon as you have a buyer's name, please, listing agents, order the title commitment. Here, I think 10 days isn't enough, that the seller is going to provide that to the buyer in 10 days. For me, I'm going to amend that to maybe 20 days because I don't want a hiccup. I want to make sure I have it. Now, yes, I'm extending that contingency, but I'm not out beyond the other contingencies that they already have. So please make sure you get a title commitment. When you call your favorite title company, tell them you're asking for a title commitment. Do not order a prelim, because if you provide a prelim, you have not satisfied this particular contingency. In addition to that, you are going to have the underlining documents with the title commitment. Now, this should be those click links, you know, the hyperlinks, that should also be in the title commitment. So you will see the hyperlinks on the title commitment as well. It is a much more in-depth dive into the property. Please make sure you're doing this right and getting a title commitment. So you're also going to ask title to provide you with a scaled and dimensional plot showing the location of easement. I always just call and order a plot map or easement, you know, plot easement map. So title will provide you that too. So along with that title commitment with the click links, so the other party can look at the underlining documents, you're going to give them the plotted easements, which title will give you. So make sure that you understand this. And make sure that you amend the days as a listing agent, because I don't think you would make 10 days. Like if they actually needed the full 10 days to get that report to you, you may need some extra days. Okay, and so once that's provided to the buyer, okay, the buyer has 10 days from receipt of that title commitment and those underlining documents in the plot to review it, okay? Survey, buyer has 30 days following the receipt. Now see, now this is going to tie to other contingencies of the title commitment and the underlining documents, okay? So now the survey is tying back to that title commitment when the clock can start running on this. Existing leases and tenancy statements. Seller shall within 10 days following the date of the agreement provide those documents, the rental agreements, and also the estoppel certificate. If you have a large building with a lot of tenants, maybe 10 days isn't enough time for you to get those estoppel certificates executed by the tenants. So you may need to amend those times. That depends on the seller and how much time they're going to need. The seller is going to use their best efforts to get each tenant to complete and execute those estoppel certificates. If a tenant fails or refuses to provide the estoppel certificate, then the seller shall complete and execute a estoppel certificate for that tenancy. And buyer has 10 days to review that. You can ask your favorite legal advisor, but the seller may not want to complete an estoppel for a tenant, but that would be something that you could ask legal, because they don't want to be, fully responsible for that. So, that's up to the seller, how they want to handle that. Okay. Owners association, if it happens to fall under an owners association, you have 10 days to provide all those the documentation. Other agreements. So if you have other agreements that are going to survive the close of escrow, that are going to continue on the property, make sure you're supplying those. If there's any leases, if there's anything like that, supply them. Maybe there's a contract for like the monitoring system, telephone system. If there's any kind of contracts that are going to stay, gardener contract, anything, make sure you're giving it to the other party for review. Okay, this is about assuming a note, so I'm not going to go over that, but personal property I will go over. In the event that there's any personal property that you've included and is going to be remain with the property, buyer has 10 days following the date of agreement to satisfy with regard to the title condition of the property. So in real estate, I am so happy that we learn something new every day, because I was like, okay, I really need to figure out what this UCC1 is. So the UCC1 is a legal form that the creditor on the equipment, if they financed it, they're going to file a UCC1 form, and you can find those at the Secretary of State website. So you want to make sure, if they're leaving equipment that could be worth, X amount of dollars, that you want to find out if there's a UCC1 filed on it, because that would mean there's a lien on it. Now, if that payment of all that equipment that will be left has been paid off, you will see a UCC3 form, which releases that lien that would be filed with the Secretary of State. So I didn't make copies of these, but I did print this out from the net. So if anybody wants copies, I'll make it. So you want to check and see if there's any liens on the equipment that they may be leaving for you, if that's applicable. So destruction, damage, or loss is an interesting clause, because it's prior to closing, there shall not have occurred obstruction, damage, or loss to the property or any portion from any cause whatsoever, which would cost more than $10,000 to repair or cure. If the cost of repair is $10,000 or less, the seller is going to go ahead and make that repair prior to closing. Now, maybe this amount needs to be amended, because, like, let's say even a small portion of a roof got, damaged. 10,000 isn't very much. It's kind of an arbitrary number. So if the seller feels this should be raised, then they can raise it to whatever amount they think, but they may not want to put themselves on the hook to repair something. But that's a seller question. Okay, I just want to point it out.
$10,000 is based on what I see on the date at the bottom, 2019, which is 5 years ago.
Yes.
So that price now probably 20,000.
Yeah, that's what I was thinking. It's very low, but it's up to the seller if they want to leave that be or not, that amount. So that's something you'll want to point out. The seller is going to repair if it's less than $10,000. And the buyer shall have the option within 10 days of written notice of a loss more than $10,000 to repair or cure, to either terminate this agreement. That's why this is important, this figure, because the buyer, if it's over 10 grand, would have a right to terminate the agreement if a tree fell on something, I don't know. I don't know, but I just want to point this out because 10,000 in today's terms is pretty low, but that would be again up to the seller how much they want to put in there. Or leave it, that's up to the seller. But us as agents, we always want to give our clients the benefit of our experience. We don't want to act as an attorney because if we're not licensed, we do not act as attorney, but we do owe a fiduciary and the benefit of our experience. That's what I always think in my mind. If I know something and I've seen something before, I have that experience, I'm going to bring that forth with my client and share with them. Okay. So material changes. The buyer has 10 days following the receipt of a written notice of a material change. Maybe a large tenant is given notice that they're not going to be occupying the space anymore. That's a material change. So any material change, the seller would need to provide to the other client, the buyer, and let them review that for 10 days. So the seller needs to deliver all the documents that are required under this agreement. Brokerage fee and payment. Okay, so Q is important for us. So payment at closing of such brokerage fee as specified in this agreement or later written instructions to escrow, which is executed by seller and brokers. It is agreed that it is agreed by the parties and escrow holder that the brokers are a third party beneficiary to this agreement. So that is another protective thing they added. And in 27.2, and we will go over that on the next class, is where you insert your percentage. 27.2. Why? Because as a buyer's agent, a lot of these commercial deals may not be on the MLS, or maybe they're not listed anywhere. You want to make sure that you're inserting your commission in 27.2 as a buyer's agent. On the other side, seller's agent, please make sure you pay attention to if there's any insertion, because maybe you only wanted to pay 2% and somebody inserted a 3%. So we'll go over that the next class, okay? But that's one that you really need to pay close attention to on both sides of the deal. So the contingencies specified in 9.1A through M are for the benefit of, and the buyer has the right to waive them if they want to. Okay. So this is where 9.3, they're going over that the buyer's timely and written disapproval or conditional approval of the buyer's contingency, that you need to do that. You need to disapprove the item. And there is a notice for it. So you need to supply that notice to the other brokers and escrow, okay? So silence equals acceptance. And that's how I always remember on this agreement, is I always have that in my mind. So if I can get my Excel spreadsheet done, I'll share it with you second class. But I think it's imperative that we all have a contingency spreadsheet, because this is a lot to manage, but we're all capable of it. And especially with a list, I love lists. I think it keeps us on track. So I am going to stop here and I'm going to address any questions, and we are going to pick up on paragraph 10 next Friday, same time, same place. And we're going to go over the disclosures and counteroffers and things of that nature. So now I am going to say, if we have any questions, if I can answer them, I will answer them. If I don't have the answer, I will be very upfront with you and tell you I'll get you the answer.
Question.
Okay.
The agreement is for all classes of commercial real estate, is that correct?
This agreement is for non-residential land, AIR. There's a land agreement, but once you can master this, you've mastered the land, and there's a multi-unit agreement.
I guess I'm not quite, sure what 3.2 means.
Okay, I'll go back over that. AIR, in answer to your question, Lorraine, it used to stand for American Industrial Real Estate Association, but now it is just AIR, and they were formed in 1960. CRE on these contracts stands for Commercial Real Estate. So we're going to go back up to 3.2. Okay. 3.1. Let's see.
The 1.5% fee. I don't get-
You know, there is a fee on a maximum of 1.5 of the unpaid principal balance of the applicable existing note. So the way I'm interpreting it, whatever the balance is on that existing note, there could be a 1.5% fee. So I wanted to point that out to you because if you're helping somebody and they're assuming, make sure you understand the fees associated and all of the assumption costs, because that is embedded in this contract. Yeah. So was this a question?
How to count the days? Because it's so many, like a 10 days, 2 days. What is the correct way? Is that the same way as the CAR?
Yes. Okay, so it's gonna say on a physical buyer has 10 days. It's gonna tell you in each category following the receipt of the property information sheet. So if you stall out on issuing like the title commitment, because some of the timelines on these are tied to the title commitment, they're tied to the property information sheet. So each contingency, that's why I think it's so imperative. And I've started making it, but I got lost in La La Land because I was busy that day making a sheet. For me, I can go down and hold this contract and kind of write on the side of it. I make a copy. But for me, I like a yes or a no check sheet. Is it done? Do they approve it? Have we notified escrow? Have we notified the other broker? But each category in here is going to tell you how the time clock starts on that contingency. So it's a little bit different. It's not just one standard answer.
So let's say.
Hazardous.
Let's say subject to certain report. So the day that the seller received the report or the buyer, that particular day doesn't count. It counted starting from the next day.
Following the
The
receipt.
following.
Yeah, and each category is going to outline that. That's why I think it's so important that you draft this out. Even if you're just drafting it out for yourself to remember it, I'll do that. I'll start making charts on my computer just because it triggers me to remember things. But this is important, and especially if you've never worked this contract, then you really need to make a list for yourself or make a copy of this and use this as your list. Okay, and all the other up top, make sure anything that you have to notify escrow of up top too that we discussed, that you highlight that as well.
So is it business day or calendar day?
Days.
Business day or?
No, it's days.
So that's calendar day.
Yes, calendar. Yeah, because if it's the only one that I see business days on in this contract is the initial deposit. Okay, so I'm going to look at what do you indicate on 2.1? Okay. 2.1, let's see. I'm sorry. Oh, here, for me, I'll say, industrial building or office building, county of, and the address here, the legal description, I'll pull it from Real List, or I'll call the title company and say, can you send me the legal description of the property? And I'll give them the APN number, ask title, any title company you wish to send you the legal description. You can insert that here. Any other questions?
Michelle Olsen, this is David Hewen.
Hi, David.
I want to, number one, just basically thank everyone in management for arranging for this webinar, this Zoom webinar on AIR CRE forms. I have purchased the forms and I have it installed in my computer at my office. I know it's very thorough, very comprehensive. The second thing, I'm also a subscriber to the commercial database issues database that are issued every Monday through Friday. So this is giving us the tools to have access to the listings for commercial properties in Southern California, as well as the contracts. So I want to thank everybody for arranging for this webinar. I do want the webinar to be recorded and sent out if we can get a link so that we can review your presentation on our own leisure on the weekends and things like that.
Okay, David, so pertaining to that, we will be going over a lot more commercial classes. So we'll decide how we're going to distribute it, but we're trying to get people to show up in person, or our other offices you are in Zoom. Because the learning takes place when you're really engaged as you are. So we're trying to figure that part out. But yes, I hear you about the link and yeah. So we'll figure that out, David. We did record today.
Okay, I'll let you know that I'm totally happy to attend in person. I think,
Oh, no, you're here. I mean, we consider you, the people from our other office on Zoom, you're here, but yeah. So thank you. And we'll figure that part out about the recording. Okay. I'll be back to you, David.
thank you again. Bye-bye.
And then Jimmy, you're saying that the AIR CRE contracts are found in zip form? Yes,
Yes.
they will be found there if you buy them for $229, I believe is the last price I saw annually. There will be a toggle switch. You can toggle between AIR and CAR forms once you buy them. It's $229 a year.
Quick thing. So once you purchase the $229 a year, you can also have access to the residential purchase agreement and the AIR, or are those
Yeah,
two?
it's a toggle switch. At first I was so confused, but you'll be toggling in between the forms. So if you want AIR forms, you toggle down, where the CAR forms show, then you toggle down and you can highlight AIR once you buy them.
Copy that. Thank you very
Okay.
much.
The zip form itself is free, but the AIR CRE form, you have to subscribe additional subscription for $229 per year. And I think it's a good deal.
Okay, great. Thank you, Peter.
Well, sure.
Michelle, do you want to add the cost per form when you utilize it as well for AIR? No?
No,
No, I don't know. I
no, you
mean,
don't. You don't need
Yeah.
to additional charge. You
Yeah.
can use the unlimited.
yeah. I'm going to stop the recording.